From a train burning that shook the Republic to a courtroom judgment that attempted to stabilize it, the Ram Janmabhoomi judgment tells us as much about the limits of law as about its power.
This was not a mere trial. How do you put history and culture and faith of a country on trial?
Perhaps the real question is not who won, but what kind of constitutional memory we are choosing to preserve.
We felt that it is our duty to actually document for posterity.
Case for Ram reflects on a moment where India's civilizational past was translated into legal language,
It is a civilizational question.
and where the judiciary was asked not just to decide a dispute, but to carry the weight of history without breaking.
And then faith comes in.
Let's welcome its authors, Senior Advocate Sridhar Potaraju and Advocate Anirudh Sharma. Thank you very much for joining us today, sir. Welcome to Lobbyt, both of you. It's an honor, actually. It's a privilege to have you both here with us.
Our pleasure.
What struck me was that usually when we're referring to Ram, we talk about various connotations, salutations that we give, like Bhagwan Ram or Lord Ram. And not that your book is very steered away from faith itself.
See, the salutation is something which we do it in our personal space as a devout. But here is a case which was brought before the court by Ram as a plaintiff. So therefore the plaintiff was referred to as Ram, like we typically use in our legal references. That the plaintiff's name, we call it without any salutations. So I think we kept it simple.
Moreover, if you find, it was Ram Lala. So Lala means the child. It was about the birthplace. So basically, the God has to be carried away in your arms. If you meet the God at that, stage when he's taken human form and he's a baby. So it also reflects the baby who's just been born at the Jamsthan.
So you call a child by their name.
That's right.
The fact that you talked about the civilizational victory when it came to the Ram Janmabhoomi judgment. 24 years since 27 February 2002 when the Sabarmati train burning had happened. Do you think that this entire journey could be viewed not only from a political lens, from a legal lens, from a courtroom lens, but also from that lens of civilizational warfare that happened for this particular eventuality that was a Ram Janmabhoomi?
Undoubtedly. I joined the team in 2017 and I also carried the same opinion that it was a political issue prior to 2017. But when I started familiarizing myself with the records, the historical documents, the witness statements, then I realized that none of the politicians or the political parties existed when the dispute was there. So how is it a political issue? It was much bigger beyond that. It was a larger issue. So in that sense, when we were looking at this case, it is naturally a civilizational battle where a worldview which believes in a formless worship comes and then tries to remove any other form of worship in idols or temple worship, because they believed that was a unapproved or a disapproved or in fact something which needs to be done away with as their religious mandate. So that was celebrated. If you read the story of civilization of Will Durant, it gives you accounts of how people actually acknowledge the genocides committed in India in the name of faith. So therefore it is a civilizational question as to what is it that we are trying to canvas here. It is on a principle that diversity is something which comes naturally to people of this land in Bharat, as against only one view, and any other view will not be tolerated, which has been introduced into our civilization or our cultural heritage through invasions, colonizations, through trade, or in whichever form it came in. So I think it was a larger scenario, a battle of worldviews, a diversity-driven worldview, which is Sanatan here, against a monolithic worldview, which is one God, one book, one prophet.
I am looking at the constitutional questions also, which people are debating so far as this judgment is concerned. Do you see that secularism per se is being debated here from a very narrow lens?
So now we need to understand what secularism is and where did it originate from and what was the need for that phrase secularism to be coined to begin with. Right? I think unless we go back to the origin of the concept of secularism, we will not be able to understand this issue. Secularism has taken birth in...
Definitely not in India, because we were always what we call a Sanatan, an inclusive society.
Okay.
So there was no control of a religion or a priest over the state, the way you saw with the church controlling in Europe, where there was a need for something and they coined and they discovered secularism. I use the phrase discover consciously because Sanatan is innately secular. So we never needed to put secularism as a part of a preamble to originally when it was contemplated and discussed in the Constituent Assembly debates. See, because French Revolution actually rejected licet of any form of faith to the extent of giving you a right to abuse, right? And then of course Charlie Hebdo and others, they're there to be seen. That's a lived experience. Now then you have UK or the British as the role model for a democracy. It's an irony that a monarchy which is a theocracy becomes your role model. For a secular republic, that's the irony at its best. Isn't it? A religious theocracy with a monarchy which is hereditary sets the table and sets the standards for us. And insofar as secularism is concerned, Bhagavad Gita is the foundation for us.
Okay.
Bhagavad Gita actually says, whichever form you worship, it reaches me if it is sincere. So that's the epitome of secularism, isn't it? Including not having any faith in God. So Charvakas are very much part of our itihasas, Ramayana, Mahabharata, refer to Charvakas and they entertain their worldviews as much as an intellectual space, right? So therefore, rational thinking and all is something which existed for us for the times we've existed as a civilizational state. So these are nothing new to us.
I want to bring you in this conversation as well, sir. I want to ask you something very specific. And this is a question that popped up in my mind when I was reading about the discussions around your book also in the past. And one of you had pointed out during the discussion that Mr. K. Parasaran had said, nobody goes empty-handed from my Ram. You recounted one of the incidents about...
That was when we were driving from the airport to the court to receive the judgment. I was curious. I mean, I just asked casually.
Right.
What do you think? What will happen today in the judgment?
Right.
So that's when very spontaneously, didn't blink. He said that nobody will go empty-handed from a Ram's place. And
Were
in
you
fact,
also there when that conversation? You weren't?
No, I was there in the airport. And in fact, if you read the plaint of Ram Lala, you will find that inclusiveness is part of the pleadings. I think people don't read the plaint. I've had friends in the bar who criticized the judgment, and the only question I asked, consciously I don't take names, but I asked him, have you read the plaint? Because you are a civil lawyer, a trial lawyer actually he was criticizing. I said, have you read the plaint? He said no, he ran away.
Well, I would like your view on that as well, sir, because it's important to understand what you think in terms of the civilizational aspect of this. What my take from this conversation till now is that Bhagwan Ram is not just a figure who was debated in the courts. In fact, you have also said that he had cultural identity. He has cultural identity, and it is a constant identity which is ongoing in India. And secularism, when you're looking at secularism, it has to be from a perspective of Sanatana, it has to be from the perspective of the Bhagavad Gita, or from the perspective of what our civilizational understanding of it is. So do you think with this book, you're trying to justify that also?
See, this book is trying to document things as they happen, and also the material on the basis of which the court considered it. See, because what happens is, you can have opinions in air, and it's only supported by your ideological helium gas, I think. Nothing to keep them floating. Your ideological prejudices or hatred. See, if you scrape the ideologues, it's hatred, raw hatred that you come across. Right? I think we should call it out. Probably that will help them heal themselves. Because see, what is the hate for? What are you hating and why are you lying? See, my problem is lack of professional or integrity of the people who actually don the hats of experts, academicians. Now, if you see the Allahabad High Court judgment, the High Court judgment has come down heavily on these ideologically driven experts who came as academicians to denounce the ASI report. Now, I think I encourage people to go, please read the Allahabad High Court judgment, observations on these experts, their cross-examinations. They are there to be seen. They have not done any archaeological study in the site. In fact, the best is some of them have not even visited Ayodhya in their life. And they give an opinion that no, there is no temple there after the ASI has found evidence. So look at the dishonesty or the lack of integrity as an expert. When you come to court, just imagine, once they have been put in the box in a cross-examination, truth has emerged. So they have been passing off so much without being tested. And any contrarian view will need space. And we were talking about times like in the 70s or 80s or 90s when the intellectual space was, I would use the phrase, probably dominated or probably hijacked, where there was no room for others, isn't it? Because they were labeled.
A few examples on these lines. What do you call secularism? The President of United States takes oath on Bible in the name of God.
Right.
Because that's the tradition there. So you cannot, attack it on grounds of secularism. I would totally support it. The Indonesian Airlines is called Garuda. Ganesha is there on their currency. So what's the problem with that? That's how they lived. In India, we have lived with the name of Ram. We have, greeted people with Ram Ram. And in fact, Iqbal, the famous poet who actually, went to Pakistan, what did he say? है राम के वजूद पे हिंदुस्तान को नाज, है राम के वजूद पे हिंदुस्तान को नाज, अहले नज़र समझते हैं इसको इमाम हिंद. So those who have perspective, those who have intellect, right, they relate themselves to Ram. This is by a Muslim, right? So Ram and the story of Ram finds reflection in the chapter on fundamental rights in the constitution, right? Why? Because Ram is protector of fundamental rights. He treats Shabri with so much of respect. He treats Kevat with so much of respect. He himself follows the law. He is the embodiment of follower of rule of law. So Ram, you can look at from two perspectives. As the person who upholds law, upholds duty. That is why perhaps Sita never curses him, because she also knows when she is sent to the forest that this man lived in the forest, traveled downwards all throughout, reached Lanka for me, because that was his duty as a husband, to look for me, to protect me. He gave everything. Now as a king, he is giving everything to that duty.
Yes.
So Ram is, sacrificing himself for his duty. So perhaps that's what even Sita, respected him for. He was never cursed by Sita, never, directly attacked by Sita, because she knew the man, what he did. So Ram is there in our fundamental rights chapter in the constitution.
I remember some aspects of the argument also, because fortunately I started my legal journalism career with this particular case, the 40-day marathon hearing. And I remember that at the time there was some conversations on theology where I don't know, I think it was senior advocate Rajiv Dhavan who was pointing out that there are structures within the mosque, they were accepting that, which are idols or which are Hindu gods and goddesses, but that was also a practice at the time for the Islamic rulers, or it was something that was a cultural identity for them also. Is that correct?
I don't think that's accurate depiction. What I would say is that, see, the existence per se would not take away the practice of worship. There is how he portrayed it.
Right.
Merely
right.
presence per se, because he says that was the nature of the cosmopolitan nature of the land, because probably most of the places were actually temples which were converted. So it will be too difficult for them to probably build fresh structures or whatever the reasons. So they accepted it. But also something which has come clearly, I think, in Mr. Gilani's submission was that he was the emperor. So therefore he was not bound by any law, unlike the Sanatan pantheon, where the rulers and even gods are subject to dharma.
Yes.
It was a contra statement there, that their ruler, the Mughals, were not bound by any law. They were law to themselves. In fact, Akbar tried to become something by Dine Ilahi himself. isn't it? So therefore, their approach to their own faith probably was not accurately in conformity with the traditional worship of Islam, maybe in India. That could be how you can probably understand the submissions in that context, explaining away presence of Hindu idols or objects of Hindu symbols in a place which otherwise would not be considered worth for offering prayer for the Muslims, because the Muslim witnesses in 1949-50 also, about 30-40 of them, given affidavits that we have other mosques to worship in Ayodhya, we don't need this place. And interestingly, the mosque was never represented by a Mutawalli at all. So that's elementary principle of Islamic law, or that Mutawalli is the competent guy in law to represent a mosque. The Babri Masjid was never represented by a Mutawalli. In fact, Justice Nazir raised this question on the maintainability itself. How can the Waqf board file in the absence of a Mutawalli? Because the Mutawalli was very much there fighting it out in other litigations. And the suit comes much later. So therefore, there's something which transpired and somebody else who got into fighting this litigation. So we don't know what that is, because there's nothing on record to actually explain the timeline and also why the Mutawalli has not come on board. So that goes to the root of their case.
Yeah.
If you have to start examining it, how does the masjid side represent without a Mutawalli? Foundational question.
Yes.
It was asked and they had no answers for it.
And you have all the records so starkly in your mind also now that even though you're recalling everything. What was it like? I just want to know, when you were writing a book, how many pages is the book?
Around 450.
And over 1000 word judgment.
Yes.
Lots of affidavits. I remember there used to be like stacks and stacks of files that lawyers used to be carrying inside the courtroom.
40,000, 50,000 pages.
Yeah, and like entire bags and everything, and even on a daily basis this used to go on, like lots of paperwork. So how did you put it in a concise manner with this book?
We had already digitized the records by then. So pre-corona, Ayodhya is the first case where it was completely done digitally. Most of the photocopiers by then had the technology of scanning the papers, because multiple copies had to be printed. So we collected all the scanned papers on a USB, and then in my office we started digitizing the whole thing. And then we realized that only digitization will not be adequate, so we had to redo it and then do an OCR on it. And I'm talking 2017-18. So when this was not really prevalent. So we did it in 2017-18, so the entire thing came to about 10 to 12 GB. So, and that was on iPad. So my iPad was there in court because it was not feasible to have 125 volumes. Each one of us, you know how the lawyers would have their own marked sets.
Yes.
So most of us had moved into digital format, and of course the seniors were using their paper books. So we had the backup digital thing. So when we would search, a couple of my colleagues would sit with laptops. We had split up the files and do a quick word search to retrieve some material or information when there's a query coming from the bench, to go to that volume and then pick it up and then give it to the senior to respond on documents. So a lot of digitization and technology was used by us in preparing for this case, and the iPad used to travel across the bench when you had to expand and see the map, to see the Makar Pranala, the various symbols which were there in photographs captured by the commissioner in 1950. So those photographs were there, part of evidence.
When we were writing this book, we were very careful that we are writing and communicating to the world at large the history of this country and how the Ayodhya dispute had to be understood, because there was a deliberate attempt to not convey the actual factual happenings that took place. For example, what was pleaded, what was conceded. There was a lot of concessions by the other side. For example, that they didn't have any evidence whatsoever till 1857 of any prayer or any ownership at all. Then their assertion that the mosque was built on a vacant land, which was totally demolished by the ASI report. Then what the pleadings were of the other contenders. How the Sunni board accepted that Nirmohi Akhara was there right all throughout, worshipping Ram Lalla in 1857, in 1860, in 1885, in 1890, in 1934. So within that 1500 square yards of the most contested land in the world, apart from Jerusalem. Right. So Nirmohi Akhara was always worshipping Ram Lalla. That was the common ground between the parties. So within 1500 square yards, it was not anyone's case that worship ever stopped, that the idols of Ram Lalla ever vanished from there. It was none of the people's case. So you will ask me, why did the case take place? When even the Muslim witnesses were saying that all throughout worship has been going on, Ram Lalla idols have been there, the Sunni board conceded that it is there. In fact, that was a huge tectonic shift, and we have a chapter in the book which is called Tectonic Shift. So we wanted to bring all these aspects of truth which are not disputed into the book and let the readers know that it is on the basis of these concessions and these aspects of truth, backed by archaeological evidence, the 1870s judgments of the Britishers, the 1885 judgments of the Britishers, which recognized this land as Ram Janmabhoomi, with further backing of the Sunni board concession that all throughout the deity was present and worship was taking place. Then they came up with a new case that half of the area which was barricaded in 1857, right, their worship did not take place. Of course, if you lock someone out, how will he go inside? So people did parikrama, they worship from the railings. These are all truths which are not disputed. So if we have so much of undisputed facts, then how do you prove a thing which happened in 1528? You are not going to call witnesses from 1528. And if you call witnesses from 1528 and they arrive, that will be serious danger. I mean,
Then everybody will run away.
yes, everyone will run away, and a lot of people will be, danger. We have movies like Street 1, Street 2 being blockbusters, but that won't be a very happy sight, right? And Babar coming with his sword and all will be very difficult, I mean, all those things. So how do you prove? You prove through these methods. So it was our duty, because we were lucky enough with the blessings of Mr. Parasaran to be part of this case and seeing a legend prove history, prove heritage. See, it was not a case which was on trial, it was the heritage and the lived history of this country which was on trial. Maybe good, maybe bad, we have to forget things.
Right.
But you have to take this case seriously if you want to understand India and how India has traveled through. And the layers of archaeological excavation also gave the same story.
I want to also reflect on how you have spoken very in admiration, admiringly about the opposite side councils also. And it is not something which is very common now. So, your reflections on that?
I think we were very privileged to be part of the generation which saw the stalwarts like Mr. Parasaran setting the standards in a matter of this nature. I can tell you this, when the matter had not yet commenced, he had very clear instructions as to the code of conduct that we will follow on our side. He said nothing which Ram will not approve.
Oh, wonderful.
That's it. So therefore, when there were instances of some provocation, which is part of the game, to disturb the other side's rhythm or whatever happened. So Parasaran sir would always hold us back. Mr. Vaidyanathan would sometimes respond, Mr. Ranjit Kumar would respond. So he would just ask them to calm down. He would send a word, please ask them to calm down. So I know why it's happening. In fact, in one of those classic, towards the end, when Parasaran sir was in his flow at 92, mind you. And there was an interjection which went on for 10-15 minutes, and then Mr. Vaidyanathan had to join hands because of the tenor in which the intervention happened, etc. Without going into the interjection. So Parasaran ji sat down, and then he woke up, or stood up gradually, and then got up and then looked at the bench. My lords, I know exactly why they did this interjection. I have not forgotten what I was arguing. And then he moved on. So he finished the entire object of that interjection with this observation. So advocacy is an art. So you need to understand that interjections are sometimes not to be taken on their face value, but they have a other purpose of disturbing the rhythm or flow of the other person. And that maturity is something which comes with experience and wisdom that Parasaran ji had. So he would let it go and not take it to heart. And then as the matter went out, I remember on the last day of the hearing, we came down. So he was not using a stick at 92, so he would hold my hand and Anirudh's hand, and then we would walk down to the car parking. So we reached the car parking. He said that, where is Dhavan? I want to take a picture with him. So he waited there for 15 minutes for Dr. Dhavan to come down. And then Dr. Dhavan had actually removed his robes. He said, sir, you want me to wear my robes for the picture? Is how Dr. Dhavan has great admiration and respect for Mr. Parasaran, and it's vice versa. Mr. Parasaran really admired the scholarship of Dr. Dhavan.
The question remains, should the Ayodhya judgment, and I'd like to end this on that note, should the Ayodhya judgment be the fulcrum on which other disputes, sir, should stand when they have to be decided?
See, if it is a civil dispute, each civil dispute has to be determined on the basis of the pleadings and the evidence which are placed before the court in a trial.
Okay.
The questions of law would definitely will have a presidential value. And also the manner in which certain spaces have been acknowledged to be composite will definitely have a persuasive value, because it's a matter for evidence in each case. See, this is not a declaration of law on facts, right? It's only a determination of facts on the basis of evidence. So therefore, each case will have to be determined on the pleadings and the evidence. In the Ayodhya case, the pleadings of some of the Muslim parties in reply was that if there's some temple found, we will voluntarily give up the claim. Unfortunately, it did not happen because some were not agreeable. So this is part of written statements of several Muslim defendants in the suit. So therefore, ultimately what I see is truth is something which is cherished by all faiths and even by atheists, because truth is the highest value and which is in Indian tradition to be discovered. So we are seekers. There is no the truth for us. Right? We keep truth. Whereas the other traditions find that the book is the final truth.
Right.
So there is a difference in approach qua truth as well. But when it comes to a court of law, the court's endeavor is to discover the truth on the basis of the pleadings governed by the procedure code and the evidence act, and then determine what is the preponderance of probability of what transpired, because it is a civil dispute. Right, so preponderance test is what is applied, and then the probability of this happening over the art is the case on facts that the court will reach to its conclusion, and then scientific evidence will have to be factored in, because on that issue, Muhammad Ismail Farooqi's judgment, the minority view of Justice Bharucha with Justice Ahmadi categorically says it should be decided on scientific evidence.
Right.
So, and that is how the Ayodhya dispute actually eventually got resolved because of the ASI excavations, because it established beyond any doubt that it was not a vacant land, as was pleaded in the Sunni Waqf Board's plaint, that the structure was built on a vacant land. The edifice of the plaint was found to be flawed. So therefore it went with the entire edifice went. So the plaint had to be actually not accepted, because if it was not a vacant land, so they tried to build up a new case of a Idgah. So a query had come up on the bench. So do you mean that they demolished a mosque to build a Idgah? Because the underlying structure did not really fit in a mosque.
Right.
So therefore they tried to develop an argument that it's an Idgah. It was an afterthought. So therefore there was no pleadings in support of that claim of Idgah. There was no amendment of pleadings after the discovery or the ASI report to set up an alternate plea that it is not vacant land, but it was built on a Idgah or something like that.
Oh.
So, so therefore, basic principles of civil law come into play. So, you should have amended your plaint and said that, sorry, we built a mosque after demolishing an Idgah. And it was not a vacant land. They didn't amend their plaints.
And the question was asked, a question was pointedly asked, if it's an Idgah, where was the place of sitting of Imam? There was no answer. So, all this is captured from public records. It's not our version, like records from Indian Express, Hindu, and put in the book.
And
Exact
it is in the
questions, so that people know what judges asked from public records, not our version, and what the answer was.
Right.
So our book is a collection of public records, and we have deliberately kept our version out of it. Justice Khan in the Allahabad High Court, while writing this judgment, which we have also quoted in our books, he says, we are going to tread in an area where angels fear to go, but the greatest risk in life will be not to take the risk. So that is how it shows the judicial mind while going through with these.
I think that answers the question itself. So that was a really wonderful conversation. I think I really enjoyed getting all the information that I got today from both of you, sir. So thank you very much. I hope the youngsters especially read this book. I think it is very important for them to reflect on the case as much as the senior people do. So thank you for talking about it and the other things that we discussed today. Thank you for
Our pleasure.
It's a
joining
pleasure.
us.
Thank you.
Thank you.